How's everybody today? It's probably against the rules for me to talk like this, but, you know, I make the rules, so how's everybody doing today? All right, good deal. Outstanding. All right, we're going to start off. I'm a Navy guy, so we're going to start on time. I only say that because there's some. No, we're not. I got a GPS. We're 10:15, right? Tracking 100%. Let me hit that little light here. My watch is broke. There we go. All right, we're going in. We're going in hot. The subcommittee will come to order. Good morning, everyone. As always, it's a pleasure. We're here to discuss 18 bills that would modernize and improve the delivery of benefits for veterans and their survivors. The bills we will discuss today will and would improve access to VA burial benefits for service members, veterans, and veteran survivors, and provide more choices for survivors to honor their veterans' loved ones buried in the U.S. and overseas. It will protect veterans' constitutional due process and Second Amendment rights, ensure quality and efficiency in the VA claims process by providing automation technology tools to process all veterans and survivors' claims, and by providing training for claims based on military sexual trauma. It will streamline the VA claims process by simplifying the forms that veterans and survivors must complete and improving the notices that they receive regarding who may represent them on their claims. Provide VA with more options for the expansion of the Dayton National Cemetery, and improve access to disability compensation examinations for rural and tribal veterans by allowing examiners to meet veterans where they are. I'm proud to have introduced one bill myself. On today's agenda, H.R. 6507, the Mark Our Place Act, would ensure that all Medal of Honor recipients are recognized regardless of when they served. Currently, VA is authorized to furnish or replace a headstone, grave marker, or medallion for Medal of Honor recipients who served on or after April 6, 1917. My bill would remove the date limitations. The service members and veterans displayed extraordinary valor, and this bill would ensure that every Medal of Honor recipient, no matter when they served, is properly honored where they have been laid to rest. I look forward to working with Chairman Boss and my colleagues on this subcommittee to advance the many important proposals today. My colleagues have worked hard on each and every one of these bills, as has the staff, to increase access to VA disability and memorial benefits for veterans and their survivors, and to streamline the VA's claims process, and expand the services provided by the American Battle Monument Commissions for the families of those service members who made the ultimate sacrifice overseas. I look forward to discussing these bills on our agenda and hearing from the witnesses who have joined us today. Mr. Duarte, good morning. The ranking member is in a meeting right now who will be here shortly, so we're going to move directly into recognizing our witnesses. Mr. Duarte from California, how are you today, sir?
Very good, thank you, Mr. Chairman.
Mr. Duarte, I recognize you for 5 minutes, sir.
Well, thank you, Chairman Luttrell, for holding this hearing today on legislation pending with the committee, including the Simplifying Forms for Veterans Claims Act, which I introduced last month. The Department of Veterans Affairs requires veterans and their survivors to complete specific forms to receive the benefits they earned in the course of their service to the United States. This includes disability ratings, health care, and pension benefits, among other things. However, we've heard from veteran service organizations that completing these forms is often difficult due to their complexity. Working with the Republicans and Democrats, I introduced Simplifying Forms for Veterans Claims Act, H.R. 8880, that takes an important step towards ensuring our veterans receive the support and benefits they earned by making the claims process as straightforward as possible. Specifically, my bill directs the Secretary of Veterans Affairs to contract with a nonpartisan, federally funded research entity to conduct a study in conjunction with VA and advocates for veterans and survivors, how to revise VA claims forms to be more understandable for veterans and their survivors. The bill will also require the VA Secretary to implement recommendations that are compliant with VA law. In conclusion, the Simplifying Forms for Veterans Claims Act builds on legislation I previously introduced, the Clear Communications for Veterans Claims Act, that directs the VA Secretary to conduct a study on simplifying notice letters sent to veterans during the VA claims process, which the full Veterans Affairs Committee forwarded to the full House in May. As a member of Congress, I would like to reiterate that it is my honor and privilege to help veterans get the benefits, health care, and support they've earned, and I want to thank my colleagues for their support on my bill, and Chairman Bost and Chairman Luttrell for advancing my bill in this committee. And I yield back the remainder of my time.
Thank you, sir. It is our practice that we will forego a round of questioning for the members. Any questions may be submitted for the record. Mr. Duarte, you're now excused, sir, if you wish. But I do understand some of you may, if you want to stay and ask questions for the next round, you're more than welcome to do so, sir. In accordance with Committee Rule 1, I ask unanimous consent that the following members be permitted to participate in today's subcommittee hearing. Representative Rosendale from Montana, Representative Valadeo from California, Representative Zinke from Montana, Representative Yacom from Indiana, Representative Duarte from California, and Representative Peters of California. Without objection, so ordered. I now invite our second panel to the table, please. Everyone ready? Joining us today from the Department of Veterans Affairs is Mr. Glenn Powers, Deputy Undersecretary for Field Programs and Cemetery Operations in the National Cemetery Administration. And he is accompanied by Mr. Jeffrey London, Executive Director of the Medical Disability Examination Office at the Veterans Benefits Administration. Mr. London, it's good to see you again, sir. Ms. Christina Messenger, Deputy Executive Director of Operations for the VBA Compensation Service. And Mr. Kevin Friel. Mr. Friel, I believe I've seen you more than anybody else in the Department of Veterans. Good to see you once more. Deputy Director of Pensions and Fiduciary Services for the VBA. Also joining us from the American Battle Monuments Commission is the Honorable Charles K. Dejoux, correct? Outstanding. Secretary and Chief Executive. I will ask all the witnesses to please stand and raise your right hand. Do you solemnly swear the testimony you're about to provide is the truth, the whole truth, and nothing but the truth, so help you God? Thank you, and let the record reflect that the witnesses have answered in the affirmative. Mr. Powers, you are now recognized for 5 minutes, sir, to present the department's testimony.
Good morning, Chairman Luttrell, Ranking Member Pappas, and members of the subcommittee. My VA colleagues and I appreciate the opportunity to appear before you today and look forward to discussing the bills on today's agenda. VA supports the following bill in its entirety: H.R. 6507, the Mark Our Place Act. We also support the unnumbered bills Permanent Licensing Portability, VA Insurance Improvement Act, Veterans Burial Improvement Act, and the Survivors Benefits Update Act, but suggest technical edits to ensure consistency within the statutes and to provide adequate implementation time. Although VA supports the concepts in the Improving VA Training for Military Sexual Trauma Claims Act and the Simplifying Forms for Veterans Claims Act, our written testimony notes several concerns with the contents of each. We also could support H.R. 2971, the Veterans Claims Education Act of 2023, and H.R. 6362, Protecting Benefits for Disabled Veterans Act of 2023, if amended. VA appreciates the intent of H.R. 7729, the Dennis and Lois Krisfalusy Act, and the unnumbered bill titled Preserving Veterans Legacy Act, each of which would address the date of death limitations in a different section of Title 38 that will prevent VA from providing memorialization or burial to spouses and eligible dependent children of active duty service members if the spouse or dependent child dies on or after October 1st of this year. However, we support the more comprehensive language in Section 101 of the Veterans Burial Improvement Act, which would eliminate the restriction in both statutes. VA must oppose several of today's bills, including the Dayton National Cemetery Expansion Act of 2024. VA has no need for additional land to expand the cemetery now or in the foreseeable future. Additionally, there is no assurance the land is suitable for use as a cemetery. The bill entitled Ensuring Veterans Final Resting Place Act proposes to amend the current authority under which a VA may provide a plaque or urn in lieu of burial and other VA memorialization benefits to a survivor who chooses to retain cremated remains of a veteran. While we do believe the law should be amended, we cannot support the concept of families being asked to pay for one benefit to preserve eligibility for other benefits. The Modernizing All Veterans and Survivors Claim Processing Act would direct VA to submit a plan to Congress regarding the feasibility of expanding VBA's automated decision support technology beyond disability compensation claims. However, this bill would duplicate VA's efforts already underway with its 5-year IT modernization plan. VA opposes the Veterans Second Amendment Restoration Act because it would require the Secretary to notify the Attorney General that VA had erred by reporting incompetent beneficiaries to the National Instant Criminal Background Check System. VA understands the sponsors of this legislation seek to restore the ability for persons VA has deemed incompetent to lawfully possess firearms. However, VA already provides individuals an opportunity to petition for relief from that prohibition. VA did not err in reporting, and if passed into law, VA could not comply. Additionally, VA opposes the Safeguarding Veterans Second Amendment Rights Act, as it would prevent VA officers and employees from participating in the execution of extreme risk protection order proceedings. This places the security and safety of veterans, their families, and communities at risk, and ultimately prevents VA from providing appropriate care for some of our most vulnerable veterans. While VA appreciates Congress's concerns regarding the Board of Veterans' Appeals' ability to attract and retain staff, we oppose the Board of Veterans' Appeals' Attorney Retention and Backlog Reduction Act. This new authority conflicts with existing personnel law and is not needed, as VA's qualification standards for general attorneys already allow for a GS-15 level, providing the duties and responsibilities that merit classification at that level. In addition, the board's current recruitment and retention incentives have dramatically improved retention rates, with attrition rates decreasing by 50% from fiscal year 2018 through fiscal year 2023. Mr. Chairman, this concludes my statement. My colleagues and I are prepared to respond to any questions you or other members of the subcommittee may have, and honored to sit next to Secretary DeJoux, who we work hand in hand with in honoring veterans and service members who have given their lives.
Thank you, Mr. Powers. Mr. DeJoux, you're recognized for 5 minutes, sir.
Thank you very much, Mr. Chairman. Good morning, Mr. Chairman, ranking members, and members of this committee. It's my delight to be here as Secretary of the American Battle Lines Commission, the ABMC, to testify on the Flowers for Fallen Heroes Act of 2024. I'd like to begin by just introducing some of my staff who are in the audience. Behind me, to my left, your right, is my Deputy Secretary, Robert D'Alessandro, the Executive Director of my Agency for Operations, Mr. Tom Spohr, and the Executive Director for my Agency for Management, Mr. Mike Conley. Each of us are multi-decade veterans, and between the 4 of us have nearly a century's worth of service to our nation, which we are very proud of. Mr. Chairman and members, I've already submitted my written testimony regarding this particular bill. In the interest of the economy of time, I'm going to summarize the written testimony. make three very quick points. Number one, the ABMC does not oppose this proposed legislation, and we thank Congressman Zinke for introducing it. Number two, whether or not this legislation passes, it is the intent of the ABMC and my agency to implement this Flowers Fund project. We will do so forthwith. And number three, I would like to emphasize to this committee, with or without passage of this legislation, whether or not my agency implements this program, I want to strongly emphasize that placement of flowers at all of the ABMC sites has been allowed, is allowed, will continue to be allowed, and we very much welcome it and encourage the placement of flowers at all of our sites around the world. Otherwise, Mr. Chairman, I stand on my written testimony and am available for questions. Thank you for your time.
Thank you, sir. The written statements of our witnesses will be entered into the hearing record. We'll now move to questioning. I'm very excited to hear you say what you just said.
Yes,
I've
sir.
had some very interesting conversations about the lack of your organizations to provide the ability for members who lost their loved ones overseas to get the flowers to the gravestones. So I'm not going to wire brush you today because I'm going to let you, what you said to me straight to my face, eye to eye, I'm going to hold you to that. And
Yes,
I'm
sir.
I'm going to, because we just met. So I'm going to take you at your word that you're going to lead that and make sure that it is absolutely profoundly done. Can we agree on that today in this committee?
Yes, sir.
All right. So I won't dig into the weeds of why there seemed to be a gap in a certain time frame of the ability for the members to get flowers to their loved ones. So we're going to move on to that one. But, so thank you for coming,
Yes,
and
sir.
thank you for doing what you say you're going to do.
Thank you, Mr. Chairman. Would you like me to explain for the record, sir? or-
Have at it. I was going to give you a leash, but you want to run with it? Go ahead.
Well, Mr. Chairman, let me begin by saying thank you very much. I appreciate the opportunity to testify. Let me also respectfully say that I very much appreciate you and your family's service. Prior to my election to Congress, I served as a member of the Honolulu City Council, and would like to just respectfully point out I was very honored to rename one of the parks in my district after Operation Red Wings. I understand the gravity of your family's service and very much
Thank you.
appreciate it. Mr. Chairman, it has been the agency's position, and this was a position taken by my predecessor's predecessor, that the placement of flowers was something better handled and left by the private sector. When it was originally launched, of course, there was no internet when my agency was originally established in 1923. However, my agency clearly hears and understands the concerns raised by Congress. We understand the concerns raised by Congressman Zinke, so we appreciate hearing from Congress, and as a consequence of that here, while flowers have always been, and I really want to strongly emphasize this, have always been allowed to be placed at all of the ABMC cemeteries around the world, we will reinitiate this as not just an allowed by private sector handling this, but my agency also taking an initiative to offer this as a program, sir.
Sure, the agency, I think, should take lead on this one, given that it's those individuals that fought and died for our country. The government needs to step in and say that we got this.
Yes, sir.
Okay. Thank you again. And if this doesn't happen, I can assure you there's some people in this room right now with you and the rest of us today. They're going to be very forthcoming of their concern.
Yes, sir.
Okay. I'll
Mr.
leave it
Chairman,
at
we
that.
hear you loud and clear. We will
All
get
right.
this done.
Mr. London, I had a question for you, sir. How often are contracting examiners required to take sensitivity training for military sexual trauma?
Mr. Chairman, thank you very much for your question. So all examiners, all contracted examiners are required to take a training before they complete any exams. They also have to recertify at least every 5 years. And if they have not conducted an exam within the last month, they must recertify to include sensitivity training.
If not every month, if they have not done an examination?
Within the last 12 months, if
12
they have
months,
not,
okay.
yes.
In 5 years, are we comfortable with that window?
Yes, we found that most examiners, they routinely do exams, so by the fact that they take the training and also complete exams and get feedback from the vendors for quality and also from our office for quality, we feel as though that the 5-year window is adequate.
Okay. I'll yield my time, and I'll recognize the ranking member.
Thank you, Mr. Chairman. Thank you to the panel. Mr. Powers, I wanted to start with you and ask you about H.R. 2971. This is the Veterans Claims Education Act. Would require more and more direct notification to veterans about where they can find accredited help in filing their claim, and clearer warnings about those who might be trying to scam them by charging egregious fees illegally. I understand VA feels they're doing a lot on this already, but I respectfully think that more can be done here to help give veterans the information that they deserve. So, Mr. Powers, can you tell me what efforts VA is currently undertaking to better promote accredited agents and attorneys, and is there harm from VA's perspective to doing more?
Thank you, Mr. Congressman, for the question. I'm going to yield for a better answer to some of my colleagues from the Veterans Benefits Administration.
Thank you very much for that question. We do agree that there is always more that we can do. Some of the efforts that we have taken to promote some of those predatory actors in the accreditation process is that in one of our notifications, or our applications, the 526EZ, as well as in our decision notifications, we do have information where veterans and beneficiaries can find a representative. And then also we have taken significant we have undergone significant efforts to make sure that we are providing information to our veterans and beneficiaries about predatory actors. And so we have had communication strategies that we've undergone that have reached up to about 32 million people. And so we're very proud of that.
Thanks for that response. Mr. London, if I can turn to you about a different bill. This is a bill I have under consideration that would expand and make some other minor adjustments to VA's insurance program. And can you explain how VA feels expanding the program to more veterans and whether that will help improve the financial soundness of the program?
Yes, thank you very much for the question. So the insurance actuaries ran a model to determine what the outcome of adding additional beneficiaries would be for the overall life of the program. And we found that by adding more healthy veterans to the rolls would actually improve the premiums and also the outcome long-term for the program as a whole.
Well, thanks for that. Yeah, it seems obvious that having more payers in the system and relatively healthy members would make it stronger from an actuarial perspective. So I thank you for that response. Mr. Powers, regarding Mr. Valadeo's bill, which is on VA's plans to make better use of AI to develop automated decision support tools and from programs other than disability compensation, I would certainly agree that VA can and should do more in terms of its use of automation tools, so long as it doesn't lead to workforce replacement. I recognize that money isn't infinite and that VA prioritizing limited resources in the area where it might provide the greatest return. So my question is, what sort of strain would it put on VA OIT if it were to have to simultaneously develop multiple automation tools for different programs with different needs?
Thank you, Congressman. Once again, I'm going to ask one of my colleagues
Certainly.
to comment.
Thank you very much for that question. I'll be able to answer that. As you may be aware, the VA OIT, in collaboration with VBA, developed a 5-year modernization plan, and we are in process of adding an addendum to that plan that goes into a little bit more detail about the efforts that we're going to take to modernize systems over the next 5 years. So we feel that the current bill that's under consideration today is duplicative of what we already have in place and that we will be able to report to you very shortly.
Well, thanks very much. Appreciate those perspectives, and I yield back, Mr. Chairman.
Thank you, Mr. Pappas. Gentlemen, we have 2 members that are in kind of a time hack here. Is there any issues with Mr. Subcommittee going, and then Mr. Zinke? Anyone else underneath the time hack? Mr. Rosendale, you good? Mr. Self? Okay. So recognize Mr. Subcommittee. Mr. Zinke, you'll go next. Mr. Subcommittee, you're recognized for 5 minutes, sir.
Thank you, Mr. Chairman. And it's good to see such a large number of bills here coming before this subcommittee, some of which I sponsor or co-lead with my colleagues on and off this committee, which I believe is a testament to the good bipartisan work being done here on behalf of our veterans. And I want to thank all of you as well for your words this morning and for the positive updates that you provided for us. I wanted to highlight one of my bills, H.R. 8881, the Rural Veterans Improvement Access to Benefits Act. This legislation builds upon two of my previous bills, H.R. 5470, the Vets Meds Act, and H.R. 5983, the Veterans Expansion Act, in order to make it easier for all veterans, but especially those in rural areas, to receive medical exams for VA claims evaluations. It does so by making permanent the VA's authority to grant license portability to medical professionals to perform exams across state lines, as well as expand the categories of providers eligible for license portability. This temporary program has proven to be successful in expediting our veterans' disability claims, which is something that I kept hearing over and over again as I came into my first term here. The disability claim time was something that I kept hearing about from our veterans, and still do so today. I have over 70,000 veterans in my district, so this was a big point here. And so these disability claims, which is why I'm proud to support this legislation. Additionally, I'm thrilled to see this legislation supported by the BFW and the DAV. Whether it's crossing state lines or crossing the street, red tape should not stop our veterans from accessing care when and where they need it. So thank you so much, and with that, Mr. Chairman, I yield back.
Thank you, Mr. Subcommittee. Mr. Zinke, sir, you're recognized for 5 minutes.
Thank you, Mr. Chairman and Ranking Member Pappas, and thank you, indulgence of the members. Today I rise and speak on my bipartisan Flowers for Fallen Heroes Act of 2024. The bill would authorize the American Battle Monuments Commission to restore the Flowering Order program to services to overseas cemeteries where thousands of Americans were killed during combat in World War I and World War II. I appreciate the Secretary's remarks that the administration is determined to begin the planning process for it. And just a reminder that, sometimes those of us in Washington forget who we serve, the people. And this issue was brought by members that have fallen members, family members there. And sometimes, we need to listen to the people out there on veterans issues. And it was the dedication and sacrifice and time spent for a very important issue for a lot of families. So I appreciate those, Mr. Chairman, on it. But it is important to also honor our commitment and remembrance of those that have given their lives in our great battles overseas and have defended the freedom that we share and enjoy today. So with that, Mr. Chairman, thank you, and I appreciate your indulgence. With that, have a great day. I'm off to appropriations.
Well, have a great day, Mr. Zinke. Thank you for coming. Mr. Self, sir, you're recognized for 5 minutes.
Thank you, Mr. Chairman. I want to address H.R. 6362, Protecting Benefits for Disabled Veterans Act of 2023. I am deeply concerned about the provision in H.R. 6362 that grants the VA discretion to award TDIU as appropriate. The language used in this section is extremely vague and raises serious concerns about the consistency of decision-making at VA. It's also subjective. Given the recent repeal of the Chevron deference, it is imperative that Congress take a more prescriptive approach when we craft legislation. Chevron allowed agencies like the VA to get away with wild interpretations of ambiguous statutes. In a post-Chevron world, the burden falls squarely on us, the lawmakers, to ensure our statutes are clear, precise, and to the point. This bill, with its broad and ambiguous language, fails to meet any of those criteria. It is our duty to provide explicit guidelines that leave no room for misinterpretation of an out-of-control administration. Ms. Messenger, regarding the TDIU bill, can you elaborate on VA's concerns regarding allowing VA to decide an award of TDIU as appropriate after considering the totality of circumstances, even when a veteran can maintain gainful employment?
Yes, sir, and thank you for that question. When it comes to the way that the bill is written, as you described, it is broad, which in normal circumstances we would say that could be a good thing. However, post-Chevron, as you mentioned, that is not a good thing. And so we do need to be prescriptive. And so the IU benefit is extremely important because it fills that critical gap when the VA schedule for rating disability doesn't fully address the impact of the service-connected disabilities in a veteran's circumstances. And so one of the areas that this bill would require is for us to consider medical expenses as well as cost of living. And so this is, aside from the administrative complexity that's involved in this, it is also, we are afraid that it would create inequity with our veterans by,
So you're suggesting we amend the bill?
yes.
Okay, because I really, Mr. Powers, when you say you could not comply with a bill, that perked up my ears real fast. So, Ms. Messenger, under current regulation, even when veterans do not meet the traditional criteria, you can grant TDIU in exceptional circumstances. Now, this bill has removed the extra scheduler TDIU award. It's removed it. It's gone. Why does VA continue to believe that it can award TDIU in exceptional circumstances even when it's not in statute? So we either amend this bill or you will, post-Chevron, not be allowed to do that. Is that correct? Is that your understanding?
Based on how the bill is written, it does remove the extra scheduler benefit, which we would like to work with the committee to be able to ensure that that is included, because that is a piece of that where veterans that don't meet the percentage eligibility, we do want to make sure that that is in the statute.
Okay, thank you for that. And real quickly on 8879, Improving VA Training for Military Sexual Trauma Claims Act. Ms. Messenger, again, I'll stick with you. Did VA provide any military sexual trauma sensitivity training for the VA employees in Roanoke?
Specific to sensitivity training, I'm not sure, but I do know that they have undergone MST training that's specific to PTSD and personal assault, as well as MST, and all of our claims processors are required to complete those.
I ask you to follow up on that because I'm told they received no sensitivity training.
Yes,
and we're
sir.
talking about sexual trauma here, so I ask you to follow up on that.
Yes, sir.
With that, Mr. Chairman, I yield back.
Thank you, Mr. Mr. Rosendale, sir. You're recognized for 5 minutes.
Thank you, Mr. Chair. Appreciate it.
I'm sorry, no, yeah, Mr. Rosendale.
Okay. Thank you very much, Mr. Chair. And thank you to the witnesses for being here today. Mr. Friel, I'm going to start with you. Actually, I'm going to keep most of my questions on you. My questions are going to be about the Veterans Second Amendment Restoration Act and the Safeguarding Veterans Second Amendment Rights Act that Representative Crane is going to be bringing through. Would you agree with me that it's imperative that eligible veterans feel comfortable receiving health care from the VA?
I would.
Thank you very much. As taken directly from the VA's mission, the core values are integrity, commitment, advocacy, respect, and excellence, known as I-CARE. Okay, that's taken directly from your mission statement. Do you think referring to veterans who need a fiduciary as mentally incompetent fulfills this mission or makes veterans less likely to pursue care at the VA?
So one thing I'd like to clarify, Representative Rosendale, is that VHA does not report individuals to NICS. That is a VBA function only.
Mr. Friel, I know the process. Okay? Stop using someone else as a scapegoat. What I'm trying to find out is, do you think that identifying veterans that request a fiduciary as mentally incompetent builds confidence in them coming to the VA and receiving health care there? When you identify them as mentally incompetent?
I do believe, because that mental incompetency decision is based
You do
on,
believe that makes them more inclined to come to VA? Okay.
I'm sorry.
I don't believe that it does, but if you believe that it does.
I do not believe that it sways them in any way, because the decision is based off of benefit, not off medical treatment.
I just think it's a very degrading terminology. That's what I think. And I think if we went around the table here and started talking to the veterans and said, do you feel comfortable with the Veterans Administration identifying you as mentally incompetent, that you would probably find that most of the veterans find that offensive as well. Does the terminology respect the contributions veterans have made to our country?
I believe, sir, that we could probably look at better language than mentally incompetent, but
So you would say that it does not recognize the contributions that veterans have made to our country?
I would say that's a bad comparison, sir, in that we are looking at making that decision based off of what the fiduciary program is and what the
All right, Mr.
statute-
Friel, are you concerned that veterans might be less willing to seek care at the VA knowing that it could result in them unfairly losing their Second Amendment rights?
I am not. As I said before, it's seeking care is not what gets you into the fiduciary program. It's actually applying for benefits that puts you into that program.
The National Academy of Sciences found that 35% of the veterans identify, and I quote, the potential of having their personal firearms taken away as an obstacle to use VA mental health services. So if the VA won't acknowledge, and you will sit here and not acknowledge this or try to change that belief, that only leads us to believe that the VA is either trying to reduce the delivery of mental health care, because we have evidence that shows that it does reduce the confidence that veterans have in going and seeking this care. And if you won't acknowledge that, and if you want to change that, then that leads us to believe that you're either trying to reduce the amount of health care that's being delivered by the VA, or you're making this an attempt to seize firearms from the veterans. VA's testimony stated that if the Veterans Second Amendment Restoration Act is signed into law, and this is even more troubling, the VA could not comply because the VA states the Department of Justice, an executive branch agency, affirmed VA's interpretation of the Brady Act. So, is it the VA's position that the VA will not comply with an act of Congress based on another agency's interpretation of the law?
So the VA has always works to comply with all laws. We complied with the Brady Handgun Act when it was in effect. The law.
So again, is the VA's position, because based on the statement they could not comply with the Restoration Act, the Veterans Second Amendment Restoration Act, is it your position that you will not comply with an act of law passed by Congress?
Yes, sir. I guess based off of what you have in testimony, yes, sir.
That you would not comply?
Yes, sir.
Well, I'm glad everybody hears that on the record, that the VA is going to refuse to comply with, regardless of what we actually pass here, including questions that Representative Self was just asking in view of the Chevron Act being passed. Mr. Chair, I have just a couple more questions, but I think that Mr. Friel has incriminated himself and the VA that they're going to have complete disregard for what we're going to do anyway. So
Mr. Friel, you're very well aware of how you just answered the congressman's question, correct?
Sir, as I said, it's in our testimony that we would have trouble complying with that law. As I said,
Mr. Friel, you're very well aware of how you answered the congressman's question.
yes, sir.
Mr. Ramirez, you ready?
Thank you, Chairman.
You're recognized for 5 minutes.
Thank you, Chairman and Ranking Member Pappas. And thank you for the witnesses for being here today. I want to begin by reaffirming my commitment to legislating with the goal of preserving life, and that being our ultimate priority. We've all heard time and time again that suicide by firearm is one of, if not, the leading cause of veteran suicide. 155 veterans have lost their lives to suicide in Illinois, and 66.5% of these veterans lost their lives by firearms. The Veterans Second Amendment Restoration Act and the Safeguarding Veterans Second Amendment Rights to Act do the opposite of legislating with the goal of preserving life. In fact, these bills disempower the VA to use the tools they have to prevent veteran suicide. And an appeals process for names added to the NICS list already exists. These bills restrict the VA's ability to find other avenues to prevent harm by prohibiting the VA from seeking or participating in the state-level enhanced risk protection orders that have proven, and we know this, to be effective to prevent gun tragedies. And so I will say to you, at least on this side, that I won't be supporting any legislation that would potentially endanger the lives of veterans, and I certainly urge my colleagues to do the same here. So let me get to my questions here. Mr. Friel, you've been on the hot seat, at least certainly since I got here. I want to start by asking you, what are some of the most common reasons for the VA determining that a veteran is mentally incompetent such so that they need a fiduciary and should be prohibited from purchasing or possessing firearms?
So the majority of the individuals that are found to be put into the fiduciary program are based off of medical evidence, where a physician says that the individual does not have the ability to manage their affairs, and they indicate what physical condition that might, or what physical or mental condition might impair them. As far as the specifics, we are currently doing a data research on that, so I don't have that answer readily available about what specific disabilities are the highest cause.
And so let me follow up with you. I want to talk a little bit more about this Veteran Second Amendment Rights Act. The language in the Safeguarding Veteran Second Amendment Rights Act prohibits the VA employees from participating in proceedings relating to a state gun confiscation law. And many states have implemented domestic violence restraining order laws that authorize or require the removal of a firearm from the person subject to the order. So like ERPOs, these protective orders are issued after notice and hearing and can result in temporary firearm prohibitions. These laws, which have existed for decades, are necessary because we know that every year more than 600 American women are literally shot to death by intimate partners. We know that domestic violence assaults involving a gun are 12 times more likely to result in death than assaults with other weapons. So my follow-up to you, Mr. Frio, is do VA healthcare providers treat individuals facing domestic violence? And let me give you the second question so you can just answer together. Are they trained to recognize signs that domestic violence may be occurring?
So I will tell you, as far as the second part, I am not a VHA employee, so I do not have that readily available, but we'll take that back. As far as the first piece, yes, we believe that this restricting VA from using red flag laws puts the safety of our veterans as well as other, their family members at risk. The number one cause in VA right now is the prevention of suicide. What we do know is that 72.2% of the veterans who committed suicide in 2021 used firearms. Mm-hmm. So we are highly concerned about making sure that that we can reduce that access. And we reduce that access, to your point about the ERPMO, is that we are truly looking at, when we put if this were to go in place, our clinicians and our VA police could not testify in those domestic violence, issues where there's potential for a beneficiary to be at risk or the veteran themselves to be at risk. And it would restrict us from being able to utilize those laws that exist within the states for those reporting purposes.
So then, Mr. Frio, do you understand this bill to prohibit VA employees from participating in domestic violence restraining order proceedings? For example, as an expert witness presenting medical evidence in support of the veteran's petition for a restraining order?
We do.
Thank you. With that, I yield back.
Thank you, ma'am. Mr. Duarte, you're recognized for a minute, sir. You good? I'm sorry. Mr. Yocum, are you on a time crunch? Mr. Duarte.
Thank you, Mr. Chairman. Happy to be here today, and thank you to our candidates, our panel. Ms. Messenger, how long does it typically take to revise a form with the form's attached instructions when reviewing a veteran's claim?
The question was, how long does it take to update the form?
Yeah, reviewing the form and get back. I'm not a veteran myself. I have many veterans in my district, and the concern I get is that just the turnaround time for veterans' claims when it comes to either families or veterans themselves making their claims is up to 12 months. Is that true?
To update a form, it can take up to 12 months.
So families are waiting for the enhanced benefits or services that they need?
No, they're
for
not.
12 months?
No. That is just to update a form. That is how long it could take anywhere from 6 to 9 to 12 months, depending on the types of changes that need to be to a form. But whenever we make changes to a form, there's still a form that veterans and beneficiaries can use that they would be submitting to us for those claims, so that we can continue to process.
So an initial claim, what is the turnaround time there?
To complete an initial claim?
Yeah.
I believe right now our average days to complete is to complete a claim is around 152 days.
And I understand that there's an IT project underway. When will that be complete, and what are the objective benefits that you expect from that?
And can you be more specific?
Well,
on
a
the
Veterans
IT?
Claims Management IT project is underway, I understand. And what benefits and timeframes is that going to improve?
I'm not sure which.
Was it someone in
the
the panel,
automation? Is this
Mr.
about
London,
automation?
was that yourself that mentioned that there's a major enterprise
Sure.
IT platform coming available?
Yes, thank you for the question. I understand your inquiry here. So currently, VA is already deploying claims automation for certain types of claims, and we have seen that that has been able to decrease the amount of time that it takes. We have a plan over the next several years to have that technology to be rolled out to all claimed contentions so that we can see reduction in the timeliness and how long it takes to promulgate a claim.
What are your goals for that? Where are we now? What are the objective timeframes and metrics you're using now? And what do you think the outcomes of that project are going to be when fully implemented?
Sure, we'll be able to get back to you with the details, but from my understanding and the last information that I saw is that we are seeing that in certain circumstances, claims that would take months or weeks, we can actually get them done within days, but we'll give you more details for you and your staff to give you specifics on where we are and the outcomes that we expect.
Okay, well, I'm a little surprised, I have to be candid with you, that we're here at a hearing on veterans claims processing and veterans claims issues, and you don't have more for us than that today. I mean, if we have a major IT program underway, if we're developing this, if we're claiming we're going to enhance these services, this is a big issue for my constituents, and so I hope that we can speak in terms of specifics in the future.
I understand and appreciate your concern, and we'll definitely get the details to you and your staff.
Sure. My colleague, Mr. Self, mentioned Chevron. Chevron really afforded two problems with the agencies, from my perspective anyways. One was it gave the agencies enormous latitude in how to interpret standards, how to interpret legislation, and sometimes drive trucks through areas where I don't think the legislation was vague, but was simply reinterpreted by the administration and its agencies. The other was a simple lack of uniformity. The same deference that gave the agencies the ability to find ambiguity, whether it existed or not, and then create law according to their own expertise or, in my sense, values, was a lack of uniformity that the agencies would then exercise this discretion with. Are you working post-Chevron to make sure that there's a uniform application of your interpretation of legislation?
Thank you for that question. We are working with the Office of General Counsel, as this is a significant change, to make sure that we are applying Chevron in the way that we need to, in a uniform manner, to your point.
Thank you. The subjectivity and ambiguity are separate problems, and a lot of us are very interested in seeing Chevron applied thoroughly at all levels in all agencies. It was a big change in how we're going to relate to each other.
Yes, sir.
Another bill on the floor, Mr. Linden. Why does the VA support the Rural Veterans Improved Access to Benefits Act?
Thank you very much for the question. The license portability authority that we have today has been a game changer, and without it, we would have been unable to serve veterans in communities where they live, especially rural and remote veterans. And the bill under discussion today would actually allow VA to assist veterans. For example, one of the highly claimed contentions are eye conditions. And today, we cannot send an optometrist to a rural area if they are not licensed in that state. What this legislation would do in this example would allow us to travel in an optometrist to meet the veteran's need where he or she or they reside.
Thank you. I'll yield back, Mr. Chairman.
Thank you, Mr. Shorten. Mr. Yocum, you're recognized for 5 minutes, sir.
Thank you, Mr. Chairman, for your service to our country, and thank you for the opportunity to testify today on behalf of my legislation, H.R. 8854, the Ensuring Veterans Final Resting Place Act of 2024. Under current law, if a veteran's family chooses to have the VA furnish a commemorative plaque or urn for their loved one, they inadvertently forfeit their right to later inter the veteran at a national cemetery, which require either a headstone or a marker at the gravesite. This issue came to my attention because one of my constituents, Miss Jerry Simmons, was attempting to get a plaque for her late husband, Mr. Gary Simmons, a Vietnam veteran. The VA had not yet implemented the Johnny Isaacson and David Rowe Veterans Healthcare and Benefits Improvement Act of 2020, which requires the VA to furnish plaques and urns in lieu of a headstone. This prompted the VA to deny Ms. Simmons' claim for a plaque, which is why she called my office for help. We were able to help secure a plaque for Mrs. Simmons after a phone call with the then VA Undersecretary for Memorial Affairs. During this exchange, we highlighted the oversight in the law and developed a solution. The Ensuring Veterans Final Resting Place Act of 2024 would allow a veteran survivor to choose to have their veteran loved one interred in a VA national cemetery, even after their survivor initially chose an urn or plaque in lieu of internment in a VA national cemetery, so long as the expense of that urn or plaque is paid for. We demand a great deal of sacrifice from our service members, but we don't often think about the burden those sacrifices place on our military families. Being a loved one for a member of the armed forces is no easy task. They are asked to move often, sometimes overseas, endure extended periods of time without their spouse during deployments, and tragically, sometimes continue life without a member of their family. Like our veterans, we owe our military families an unpayable debt. We grant veterans the final honor to be interred on solemn grounds at a national cemetery, but those logistics are left to the veterans' families. The death of a family member is always a difficult time, and seldom do arrangements after a death go smoothly. Sometimes families do not immediately know if they want to have the remains of their loved one interred at a national cemetery, or they simply may not want to part with the ashes right away. So in that case, they may opt to have an urn or a plaque. This snap decision has permanent consequences as the law is currently written. We must allow the grieving families of Americans' veterans the flexibility to wait or choose whether or not to inter their loved ones at a national cemetery. And we shouldn't deny veterans that right simply because their remains were placed in a VA urn. Thank you, Mr. Chairman, for the opportunity to testify today. I do have one brief question. Mr. Powers, how much does a VA furnished urn or plaque typically cost the VA?
Thank you, Congressman, for the question. And we implemented the plaque and urn about a month ago, and we were happy to provide your constituent the second one. The first one was provided to the widow who initially made a constituent request to her congressman, and we understand she appreciates the plaque that we gave her. In answer to your question, the plaque costs us $179.69, and the urn costs $370.67.
Thank you, Mr. Powers. I appreciate your answer, and thank you for finally implementing that law. And with that, Mr. Chairman, I yield back.
Thank you, Mr. Yocum. Mr. Valadeo, sir, you're recognized for 5 minutes.
Thank you, Chairman Luttrell, members of the subcommittee, and witnesses for taking time to hold this important hearing today. Veterans across the country and in my district are being impacted by long wait times when it comes to receiving their benefits. While these delays can happen for all sorts of reasons, one source of this delay is outdated technology throughout the Veterans Benefit Administration and the VA Board of Veterans Appeals. These unnecessary delays are harmful to veterans and survivors. We need to ensure our veterans have timely access to the benefits and services they've earned. My legislation, the Modernizing All Veterans and Survivors Claims Processing Act, would require the VA to create a plan and report to Congress on making automation tools available for the purposes of processing veterans and survivors' claims for VA benefits. This is an important step to equip the employees at the VA with the tools they need to better serve our veterans. Now I just have a couple questions for Ms. Messenger. Ms. Messenger, why is the VA opposed to simply providing Congress with a report on the extent to which it is feasible and beneficial for the compensation service automation technology to be implemented in other VA program offices?
Thank you for that question. I am going to defer to my colleague, Mr. London.
Thank you very much for the question. As I stated earlier, VA is implementing the Section 701B of the PACT Act legislation and required it to provide a report on how we plan to modernize the claims process and benefits delivery to veterans. And we are in the process of providing an addendum to you and other members of Congress on the plans that we have to not only deal with disability compensation, but also the other benefit programs that we administer.
All right. And then follow up on that, and I don't know if you want to defer to Mr. London on this one as well, but all types of veterans and survivor claims require VA employees to send letters. Why doesn't the VA provide all program offices with automated letter packs that compensation services uses?
If I understand your question correctly, you're saying that a compensation service use automated letters. Your understanding is other programs do not. I am aware that there are projects underway to allow other benefit programs to have access to that technology so they can have symmetry across programs.
All right. Well, I appreciate your responses. Thank you, Chairman. I yield back.
Thank you, Mr. Valdeo. Mr. Peters, you're recognized for 5 minutes, sir.
Thank you, Chairman Luttrell, and to Ranking Member Pappas for holding this hearing. It's a privilege to be here to discuss my bill, the Veterans Claims Education Act. This bill is a simple but meaningful step that Congress can take to address the threat posed by non-accredited entities, or claims sharks, to veterans' hard-earned benefits. Specifically, my bill would require VA to inform all veterans filing a claim that there are accredited entities that can assist them, provide an online search tool that lists accredited entities, and require a public website where veterans can report unaccredited entities that target veterans by charging a fee for their services. I'm so fortunate to represent one of the largest concentrations of veterans in the San Diego area. This bill is a response to a constituent's plea for help. Once they realized how much of their monthly VA check would go to a non-accredited company they hired to file their claim. It's unconscionable to think that companies would prey on a veteran's desperation for profit. This bill would give veterans in San Diego and throughout the country the information they need to readily access information and free resources without fear of being swindled by a shady company. This bill has bipartisan support in the Senate and has the endorsement of multiple veteran service organizations, including the American Legion, the Veterans of Foreign Wars, Paralyzed Veterans of America, and many others. When our brave service members raise their hands and swear an oath to the Constitution, we in turn make a promise to care for them and their families. Whether it's taking care of their health, their retirements, or their educational aspirations, we say that we'll be there. And too often we fall short of this promise. And that's a lot of the work that we do on this committee, and I appreciate your work on that. But the least we can do is give our vets and service members, the backbone of our country, the tools to easily claim what we've promised them and what they've earned. Thank you, Mr. Chairman. I yield back.
Thank you, Mr. Peters. Mr. Crane, sir, you're recognized for 5 minutes.
Thank you, Mr. Chairman, for holding this hearing today. I'm going to start with you, Mr. Friel. When a fiduciary decides they are going to report a veteran to NICS, do they look at any findings that a veteran is endangered to himself or others? Do they look at mental health records? Do they look at arrest records? Do they look at judicial records?
So yes, so today, when we report someone to NICS, we are following the Appropriations Act of 2024, where we are only reporting those where we have a court finding or order of potential harm to self or others. We do not actively search for those. We do rely on first-party information, or if the veteran were to have, say, a court-appointed guardian or custodian, then we would seek to see what the order is. But we are not actively investigating or doing background checks on any veteran put into the fiduciary program.
Thank you. Ms. Messenger, do VA employees currently initiate or participate in any state proceedings to temporarily confiscate any veteran's firearms, even when experts on red flag laws inform us that such proceedings would provide them with no adequate opportunity to defend themselves in court?
Thank you for that question. I am going to yield to Mr. Friel.
So just so I can clarify, make sure I'm giving you, you're asking, is there anything currently where VA is pursuing those red flag laws or are participating in those? Is that?
Yeah. Yes. Participate in any state proceedings to temporarily confiscate any veteran's firearms.
So the VA unto itself does not confiscate firearms. It's not within our purview. However, VA police...
That's not what the question was, sir. Do VA employees currently initiate or participate in any state proceedings that go on to temporarily confiscate a veteran's firearm?
Yes, they could be ordered. They could testify. VA police or clinicians could testify in hearings where there's domestic violence or in an area where the veteran may have to be temporarily in residence medical care. So yes, in those cases, they would participate in a hearing.
Mr. Friel, did you tell Congressman Rosendale earlier that you would not comply with laws passed by Congress that overrode the VA's interpretation of law?
So I'd like to clarify.
Please do.
So within the VA perspective, you know, we have put in our testimony that the Secretary could not comply. I work within the VA. I work for the Secretary. So we would, as the instruction is provided to us, we would demonstrate and implement as we are directed to do so.
By who?
By the Secretary.
Do you see how that creates a problem, sir? Do you recognize that the position that you're taking in this room today takes the power away from the people in this country who send representatives to Washington, D.C. to become lawmakers?
I do.
So then why is that your position?
So
do you not care, sir, that this country was formed and founded by the people, for the people?
I do, and I have taken an oath to uphold the Constitution.
Well, then why would you take a position like that?
So as I said, I work for the Secretary, and we would follow the guidance.
Oh, so you work for the Secretary, so you would override what the people and the Constitution actually say. Is that what you're telling me, sir?
So I would be following the direction provided to me by my leadership.
Okay, so if he told you see how far down the rabbit hole we can go with that, sir?
I do, sir.
If he told you to do stuff that was unconstitutional, you'd do it? That's what you're telling us?
No, sir, I would.
Who are the lawmakers here in Washington, D.C.?
It's this body, sir.
Is it unelected bureaucrats?
No, sir.
Did the Secretary of Veterans Affairs, did he get elected by the people of the United States, or was he appointed?
He was appointed, sir.
Right. Was I elected?
Yes, sir.
Was the chairman elected?
Yes, he was.
Yeah. So you see the problem?
I do, sir.
So where are your where is your loyalty, sir? Is it to the Constitution or is it to your boss?
My loyalty is to the Constitution. However,
doesn't seem like it, Mr. Friel. Especially the problem is, sir, you seem like a nice guy. The problem is we're talking about veterans' rights and due process and their right to bear and keep arms, another constitutional premise. But you're willing to do what your boss tells you to do, even if it violates their rights.
And sir, we have conflicts of
You should do some soul searching, sir. You really should, on where your loyalties lie. And unfortunately, you're definitely on the wrong side of this one, constitutionally. Thank you, Mr. Chairman. I yield back.
Thank you, Mr. Crane. Mr. McGarvey, you need a minute, sir?
I'm good. Thank you, Mr. Chairman.
You're recognized for 5 minutes.
Thank you, Mr. Chairman. Thank you, Mr. Chairman. Appreciate you having this hearing today. Appreciate everyone being here today. I'm glad we are progressing on a bipartisan basis for a good percentage of these bills. I think that's what this committee does so well, is take care of the men and women who are willing to put on a uniform and take care of us. I would be remiss today, though, if I didn't register my concern over two of the bills today. The Veterans Second Amendment Restoration Act and Safeguarding the Veterans Second Amendment Rights Acts. The reason I register concern over these is I'm afraid they're going to put veterans' lives in danger. Right now, 18 veterans a day die by suicide, 13 with a firearm. We cannot divorce ourselves from the reality of this topic or the reality of the fact that the most at-risk group for suicide in this entire country are men over 50 who served in the military and own a firearm. The VA already provides an avenue for appealing the decision if a veteran is wrongfully placed on the NICS list. Wrongfully placed on the NICS list. We've had that discussion multiple times at different hearings and roundtables. And I can't support this tool removing it entirely when we're talking about the well-being of veterans. Veterans are still allowed to own firearms. This is if a veteran is found in some way to not be completely competent about purchasing new weapons. And I think it is on us to keep veterans safe. I also understand we don't want to discourage veterans from going to the VA, and I think that is worth talking about. But for veterans' safety, I just have to urge my colleagues to rethink this particular approach and get back to the drawing board in a bipartisan manner. So, Mr. Chairman, I ask unanimous consent to enter into the record a joint letter from Brady, Everytown, Giffords, and March for Our Lives about these two bills.
So what?
Thank you. I also want to talk about ways to improve the functions of the VA to be more responsive to our veterans. My bill, the Board of Veterans Appeals Attorney Retention and Backlog Reduction Act, would grant BVA the authority and flexibility to promote attorneys to the GS-15 level if they so choose, and not be capped at GS-14. Mr. Powers, I know you don't represent BVA, but as the VA witness, I'll direct my questions to you. As you know, the VA wrote in its testimony that it currently does not support the bill. In 1994, Congress put veteran law judges, also known as board members, on the administrative law judge pay scale. Yet, we also know that the BVA attorneys are the ones who often write the decisions. Mr. Powers, do you think it's hypocritical of BVA leadership to oppose a bill that would give frontline attorneys an opportunity for a higher salary, while the people who supervise the frontline attorneys have benefited from a similar change for 30 years? In other words, leadership was placed on a higher pay scale 3 decades ago and are now against allowing their workers to be bumped up a bit. As a manager, do you think that's fair?
Thank you for the question, Congressman. As you said, I don't have a lot of expertise on the board and these decisions that were made. The reason we opposed, the VA opposes the bill, was because of it's not aligned with personnel law, and therefore we can't support the bill.
Okay. And you probably can understand my reason for allowing the flexibility for, if it happens, for people who are working and serving in the VA, serving our veterans, to be able to get a little bump in pay, if nothing else, for the retention, for the recruitment, for the morale of the people looking after our veterans. I do want to highlight some of the discrepancies, right? The BVA leadership cites budgetary concerns as a reason to oppose this bill and paying their employees what they're due. Are you aware of how much money the board returned to the Treasury unused last fiscal year?
Congressman, I am not.
Okay. The BVA returned $15 million that they did not use. That's more than I'll ever make, but that number is certainly enough to pay for about 1,500 attorneys to go from the GS-14 step to the GS-15 step. So GS-14 step 4 to GS-15 step 1, about a $10,000 increase each. And we know the number of attorneys actually promoted under this bill wouldn't be nearly that high. Plus, BVA only has about 1,000 attorneys. So this bill simply gives the BVA the discretion to raise the pay of top attorneys if they so choose, within their existing appropriations. I think if we're serious about addressing the case backlog, the 200,000 case backlog, and if we know that there are experienced attorneys who have experts in veterans law for years and years who are leaving elsewhere for higher pay, then we've got to do something. And this bill is a great step in addressing the recruitment, retention, and the service to the veterans that we also so want. Mr. Chairman, I'm out of time, and I yield back.
Thank you, Mr. McGarvey. We'll move into a second round of questioning. Mr. Friel, sir, after Mr. Rosendale's question, I was going to express my concerns that you were walking on thin ice, but I think you've absolutely fallen through the water, into the water, and you've put the secretary in an awkward position, I think, and I'm disappointed in that. You or no appointed official has the right to subvert the will of Congress. We speak for the will of the people, okay? And I highly recommend you go back and listen to the testimony you gave today in response to the questions you were asked by the members of this committee. You understand?
Yes, sir.
Thank you. Mr. Pappas, do you have a question, sir? Ms. Ramirez? Mr. Self, you're recognized for 5 minutes, sir.
Thank you, Mr. Chairman. Mr. Powers, What's the average amount that VA reimburses for domestic transportation of a deceased veteran to a cemetery? Currently.
Thank you for the question, Congressman. And by the way, the transportation allowance is so critical, and that's one of the ways we partner within the VA. And Mr. Friel and the Pension and Fiduciary Service can more appropriately answer that question.
Yes, sir. Today, we make a full payment based off of the receipts that we receive, but on average, based on analysis we did it like 2 years ago, it's about $670 per.
So how did you arrive at the $745 for your proposed flat fee?
We looked at cost of living adjustments and looking at, making sure that we could provide the best benefit possible. So we increased the amount higher than what we were doing for average, for the fact that we realize people pay more, and the cost of funerals continues to go up, and the transportation allowance with.
But I don't understand. Your current is six what?
So our current is full benefit. So
right.
The current is whatever the cost of that.
But the average is six.
And that was a couple years ago, sir. So I'd have to go back and re-pull the numbers to give you more current.
But
data.
you just quoted $690.
And I did say it's about 670, 690, but that was from data from a few years ago.
Interesting. Mr. Friel, I'll stick with you. I want to know more about why you believe, and we've heard your testimony, why do you believe that the VA could not comply with this bill if it goes into law?
So, sir, at the time when we reported all these individuals, we were following the law, the Brady Act, which required, as interpretation, where individuals.
I understand what you were doing in the past.
Right.
What I'm focusing on is in the future. If this bill becomes law, why do you think you could not comply?
I think the struggle is, sir, is that we are being requested to go back and tell DOJ that we reported an error, which we don't believe we reported those individuals an error. We were following the law of the time, which was the Brady.
I'm not talking about the law at the time. I'm talking about this law.
Right.
If this bill becomes law, I want to know why you could not comply with the current law.
If the bill became law, as I said, I think the issue we have within the bill is the fact that we're saying that
the issue you have with the bill is to obey it. You're the executive branch. That means you execute the laws of this land as this body passes.
And as I said, I believe the concern is that we are being asked to go back and remove everybody who's already previously been reported, which we did.
Whatever the law requires, I agree with the chairman. You have put the secretary in a bad position, because we have often talked about this lawless administration on the border. We now see subpoenas. We're now having to go to the second level of subpoena on the Attorney General of this nation, and now you sit here and tell us that you're not going to comply with the law. This is more than concerning, Chairman, and I yield back.
Thank you, Mr. Self. Mr. Ramirez, Mr. McGarvey, anything? Mr. Pappas? Mr. Crane, you're recognized for 5 minutes. I'm sorry.
Back to you, Mr. Friel. Earlier, I asked you if when a fiduciary decides they're going to report a veteran to NICS, do they look at any findings that a veteran is in danger to himself or others? I.e., do they look at mental health records? Do they look at arrest records? Do they look at judicial records, et cetera? And I believe you said no. Is that correct?
We do not actively pursue them, yes, sir.
Okay. Do you see why that might be a problem, sir, as far as reporting a veteran to the National Instant Criminal Background Check System without looking at any of those things? Do you see how that might be a problem for a veteran?
So we are
maybe purchasing a firearm and being able to exercise those constitutional rights that I was talking about.
Yes, sir. There's two pieces there. Right now, we are following the Appropriations Act of 2024. We are only reporting those in which we have information of a court finding or order where a beneficiary is a threat to.
I understand that, sir. I'm asking you, do you see how that might be a problem with overstepping veterans' constitutional rights to due process?
I do, sir, but I want to emphasize that VA's #1 concern is veteran suicide. And as I said, 72% of the veterans who committed suicide in 2021 did that through the use of firearms. So that is our major concern, and it's one of the things that we continually strive to work.
Mr. Friel, does the VA, do you have any studies that you can cite that show that veterans are more at risk of firearm suicide if they are simply unable to balance their checkbooks and therefore need a fiduciary to manage their finances? Do you have any studies showing that?
So I don't have information readily available, sir, but I know there are studies that say that people who are at financial risk are more likely to have a higher propensity towards suicide.
Yeah. What about people that feel like their constitutional rights are being trampled on? Do you think they might have a higher risk of harming themselves? Not being able, somebody who came from a military unit and came home, and because they need somebody to help them balance their checkbook or help them with their finances, is now stripped of their right to protect and defend themselves and their family. Do you think that might cause stress on an individual?
Well, we do not just put people into the NICS program, as I said, under current processes, but we do offer due process when we make the finding of a proposed incompetency. And we also have an opportunity for relief and the opportunity to appeal our decision. So there's multiple avenues for a beneficiary to seek relief from being put into the NICS program. And as I said, today we are only currently reporting those where we have a court order or decision.
Thank you. I yield back.
Thank you, Mr. Crane. That's all the questions we have. This panel is excused. The next panel, please, at your leisure. Mr. Friel, may I have a word with you, sir? Thank you. Still good morning. Good morning. Mr. Holliday, how are you? Are you in a good mood? A little bit. I guess I'll take that. I'll take what I can get. So today, I'll introduce our third panel, Ms. Candace Wheeler, Director of Government and Legislative Affairs for the Tragedy Assistance Program for Survivors. Good morning. Ms. Leslie Witter, Senior Vice President of Advocacy at the National Funeral Directors Association. Good morning, ma'am. Mr. Bob Carey, Director of National Defense Committee. Sir. Mr. Robert M. Holliday, Gold Star son of Captain Carl O. Hap Holliday. Sir, good to see you again. And Ms. Nicholas Keogh. Mr. Nicholas, sorry. That was an accident. Second Vice President, Local 17, American Federation of Government Employees. I please ask the witnesses to stand. Mr. Holliday, can you please? I know you got some bad knees, sir. Please raise your right hand. Do you solemnly swear the testimony you're about to provide is the truth, the whole truth, and nothing but the truth, so help you God? Please be seated. Thank you, and let the record reflect that all witnesses have answered in the affirmative. Ms. Wheeler, you're now recognized for 5 minutes to present the testimony of the Tragedy Assistance Program for Survivors.
Chairman Luttrell, Ranking Member Pappas, and distinguished committee members, the Tragedy Assistance Program for Survivors appreciates the opportunity to testify on legislation impacting our veterans and surviving families. We support the majority of these important bills and will focus on our top priorities. TAPS thanks Representative Peters for introducing the Veterans Claims Education Act, which ensures veterans and survivors are made aware of the free resources available for filing a VA claim. Since the passage of the PACT Act, there has been an influx of media advertisements and solicitations from predatory claim consultants. Historically, veterans and survivors have been vulnerable to predatory actors, and claim sharks are no exception. TAPS is committed to protecting surviving families from being exploited by predatory claim actors when numerous free options are available. TAPS applauds Representative Zinke for introducing the Flowers for Fallen Heroes Act. This important bill aims to reestablish the Flower Program, which offered a meaningful way for survivors to honor their loved ones who died in service to our country and were laid to rest in American military cemeteries overseas. The Flower Program was administered by the American Battle Monuments Commission and operated successfully for 65 years until it was discontinued in 2015. TAPS is proud to stand with the American World War II Orphans Network to support the reinstatement of the Flower Program, and we ask Congress to preserve it in perpetuity. TAPS thanks Ranking Member Pappas for introducing the Survivor Benefits Update Act. We support Section 2 of the bill, which extends the timeline for surviving spouses of Persian Gulf War veterans to apply for VA survivor benefits. However, we oppose Section 3 regarding the processing of survivor benefit claims, which changes shall be considered to may be considered. This change would require survivors to determine which benefits they qualify for and file a separate claim for each. Under current law, survivors file a single claim to be reviewed for all benefits. Although TAPS appreciates the intent to streamline the survivor claims process, it should not shift the burden to our survivors. TAPS is grateful to Chairman Luttrell for introducing the Mark Our Place Act. This important legislation removes time limitations on burial benefits for Medal of Honor recipients and ensures they receive the recognition they have earned and deserve. TAPS appreciates Representative James introducing the Preserving Veterans Legacy Act. This bill provides permanent authority to the National Cemetery Administration to bury eligible spouses and dependent children who predeceased their veteran or service member. The current law sunsets on October 1st, 2024. Our military families serve and sacrifice for our nation and should be afforded the honor of burial with their loved ones in a VA national cemetery. We urge swift passage of this critical legislation before the current law expires. TAPS thanks Representative Rauschenbauer for introducing the Dennis and Lois Krisfalusy Act, which would allow spouses and dependent children to be added to a memorial headstone or marker regardless of their date of death. TAPS appreciates this bill would extend the federal law for 10 years, and we recommend it be made permanent. TAPS is grateful to Representative Yacoum for introducing the Ensuring Veterans Final Resting Place Act. This legislation would allow surviving families to reimburse the VA for the cost of an urn or plaque for their deceased veteran if they elect to inter them in a VA national cemetery. Surviving families who elected to receive an urn or plaque were unaware this decision would forfeit burial benefits for their veterans going forward. This has caused surviving families additional emotional and financial stress. TAPS thanks Representative Vallejo for introducing the Modernizing All Veterans and Survivor Claims Processing Act. This bill expands the use of automation tools to process veteran and survivor claims to help improve efficiency and timeliness. TAPS supports the Improving VA Training for Military Sexual Trauma Claims Act. This critical legislation would establish MST sensitivity training for VA claims employees and contracted healthcare professionals and require VA to update it annually. Improving MST sensitivity training is vitally important to safeguarding the ongoing physical and mental health of MST survivors. TAPS is grateful to Ranking Member Pappas for introducing the Veterans Burial Improvement Act. This comprehensive legislation mirrors provisions within various standalone bills. Combined, they honor our veterans, service members, and their survivors. TAPS thanks you for the opportunity to testify, and we look forward to your questions. Thank you.
Thank you, Ms. Wheeler. Ms. Woodard, you're now recognized. It is Woodard, I'm correct? Okay, thank you. You're recognized for 5 minutes.
Chairman Luttrell, Ranking Member Pappas, and members of the subcommittee, thank you for the opportunity to testify before you today on behalf of the National Funeral Directors Association. I'm Leslie Witter, Senior Vice President of Advocacy for NFDA, representing over 20,000 licensed funeral directors and embalmers throughout the nation. NFDA, with its extensive national network of over 10,000 funeral homes, remains steadfast in our commitment to ensuring that every veteran receives a dignified final tribute, honoring their dedicated service to our country. Mr. Chairman, NFDA extends gratitude to you and your fellow veterans in Congress for your service to our nation, both on Capitol Hill and in the armed forces. We commend the committee for its ongoing efforts to ensure veterans receive the benefits they have earned through their sacrifice and service. Today, as the committee deliberates on 18 bills addressing critical issues affecting veterans, NFDA appreciates the opportunity to provide our perspective on matters related to funeral and burial benefits. We enthusiastically support your legislation, H.R. 6507, known as the Mark Our Place Act. This legislation is crucial to ensuring that every veteran continues to receive the memorialization they deserve. Similarly, NFDA supports H.R. 7729, which expands eligibility for headstones, markers, and burial receptacles to include certain individuals who passed away before November 11, 1998. Furthermore, NFDA endorses H.R. 8792, the Flowers for Fallen Heroes Act, designed to establish a program for ordering flowers at grave sites overseen by the American Battle Monuments Commission to ensure that over 200,000 Americans who perished in World War I and II are respectfully memorialized in perpetuity. Additionally, NFDA supports the Veterans Burial Improvement Act, particularly its provisions making certain burial benefits permanent for spouses and children of armed forces members who die while on active duty. We also endorse the provision enabling the Secretary to cover a standard transportation allowance for transporting a veteran from the place of death to a designated cemetery. Mr. Chairman, funeral directors advocate passionately for every unclaimed individual to receive a dignified funeral and burial. Having collaborated closely with the VA and the NCA, we understand the challenges posed by grave sites containing commingled remains or multiple individual graves. The current limitations prevent the provision of a single headstone for each individual in these circumstances. We firmly support this legislation, which empowers the VA to furnish a group burial headstone or marker for eligible decedents, while ensuring that every effort is made to acknowledge each individual by name whenever feasible. NFDA stands committed to advocating for dignified treatment of our veterans, and we urge the committee to support this legislation. Mr. Chairman, funeral directors nationwide firmly uphold the principles that decisions made by grieving families should not compromise a veteran's rightful entitlement to burial in a veteran's cemetery. While we commend the VA's efforts to offer burial options through the commemorative plaques and urns for veterans whose cremated remains are not interred, NFDA has raised concerns about a provision in Section 2207 of Public Law 116-315. This provision risks confusing the purchase of merchandise with a veteran's fundamental right to burial in a national cemetery. NFDA has underscored this to the VA, our concern that a grieving spouse might unintentionally jeopardize the veteran's eligibility for ground burial by opting for an urn benefit from the VA. This contrasts starkly with privately purchasing an urn, which does not impact burial rights. Therefore, NFDA supports legislative adjustments that allow families to reimburse the VA for an urn provided by the VA, thereby safeguarding continued eligibility for interment alongside their spouse in a VA or national cemetery. In alignment with this stance, NFDA supports Ensuring Veterans Final Resting Place Act. In closing, I would like to express my sincere gratitude for the opportunity to testify before you today on behalf of the National Funeral Directors Association. I hope my testimony has provided valuable insights, and I'm happy to address any questions you have.
Thank you, Ms. Witter. Mr. Carey, sir, you're recognized for 5 minutes.
Thank you, Mr. Chairman. Members of the subcommittee, frankly, I'm gobsmacked by Mr. Friel's comments. And so my testimony I had to rewrite, so let me go into that. I'm sorry, sir? Okay. I started, and I may have misunderstood it, but I started with his statement that a fiduciary determination has no impact upon seeking mental health care. And then he went into saying that care is not what leads to the fiduciary process, it's the applying of benefits. But the fundamental fact is that I put in my 18 July 23 testimony, and today's testimony is, in fact, any rating official or any clinician in the VA can refer someone to the fiduciary program. And then the veteran is responsible for, has 60 days to prove their competency, not the other way around. The burden of proof lies upon the veteran to prove their competency, not upon the VA to prove their incompetency. He also says that suicide prevention is their #1 goal, but the fact of the matter is that the VA has repeatedly refused to examine the issue of combat exposure and veteran suicide risk, despite the fact that the 2016 VA suicide study specifically showed that combat veterans had a suicide risk of about 4 to 5 times that of overall veterans. But now they say there's no linkage between the two. We're no longer going to look at that. The fact of the matter is that, and I'm going to, as I discussed in my testimony, I'll discuss here in my oral, the VA cannot be trusted in this issue. It will do whatever it is necessary, laws or not, to report veterans to the NICS database and to states as mental defectives. And what I want to discuss now is that fiduciary program. It is not that the fiduciary program law, it's not that this is what the law was at the time. That law was it was a regulation. And that regulation was fundamentally not in compliance with due process or due process rights. The fiduciary program, before it even gets to the NICS database, before it even gets to the determination and the reporting to DOJ, is fundamentally not in compliance with that veteran's due process rights. As I detailed in my July 18th, 2023 testimony, the veteran's disability benefits have legal standing as personal property, only subject to control through a judicial due process, and that was Cushman v. Shinseki. But Goldberg v. Kelly found the due process clause requires an evidentiary hearing to deprive. And, quote, recipients are at the mercy of a vast bureaucracy without procedural protections, which could be turned into an arbitrary decision-making. Therefore, quote, individuals need to be protected from the bureaucracy. I would argue that Mr. Friel's commentary today makes that even more so. And now with Loper v. Raimondo setting aside Chevron deference, I think there's going to be a lot of people that are going to have a good case to say, why was I referred? The The fact of the matter is the VA's fiduciary program does not meet the legal standards for adjudicating these deficits. There is no independent oversight. It does not even meet the Bureau of Alcohol, Tobacco, Firearm, and Explosives definition of mental defective. In effect, VA has made themselves, I believe unconstitutionally, the legislature, the executive, and the judiciary in order to be able to make these findings. And only VA can cure this finding of mental defective. I get it. VA reports to DOJ. DOJ then sends you the letter saying you have been found to be a mental defective. You can no longer purchase or possess a firearm. But the finding of mental defective is by the VA. And therefore, it is only the VA who can cure that. And there is no process for appeal of that underlying process. The appeal process is only over at DOJ to be said that you were not, that you shouldn't have been put into the fiduciary program. But the fundamental finding of mental defective, that can only be cured by the VA. That is why we need the Veterans Second Amendment Restoration Act, because that's the only way we're going to get that done. Furthermore, given the fundamental due process and taking clause constitutional problems with the fiduciary program before it goes to DOJ, the only procedure that will work will be the safeguarding Veterans Second Amendment's rights. Happy to answer any of your questions. Sorry that I was a little disjointed, but remarkable day.
Thank you, Mr. Carey, and absolutely, this is a place that you can do that, rest assured. Mr. Holliday, sir, you're recognized for 5 minutes.
Chairman and everyone on the committee, I'm Bob Holliday from Des Moines, Iowa. I'm here asking you to see that the Flowers for Fallen Heroes Act is passed. I think let's look at this way. Everybody in this room and everyone who is a citizen of the United States lives in the most free country in the history of this planet. But those freedoms have come with a price. And the price has been the death of our soldiers or those that have served with the uniform. It's that simple. Let me give you some numbers. World War II, there were 407,000 Americans that lost their lives. That averages 220 people a day, Americans that were killed, for that matter. And about half of that number is either buried overseas or at sea on the wall of a missing, for that matter. Now, the American Battle Monuments Commission was in here today. In 1923, Congress gave birth to that organization to build and maintain the overseas cemeteries. I know you've all seen them, pictures, or maybe been in them, for that matter. Now, with that said, by 1950, the ABMC realized that no one could simply get in their car and go visit these graves overseas. They themselves gave birth to the flower program. And I think, sitting here today myself, and with me, by the way, is Marilyn Lawrence, who's behind me. Her dad was a B-17 pilot who was killed in World War II. And so we are here absolutely representing Gold Star families that have people buried in these cemeteries. By 1950, as I say, the ABMC realized we could not visit these cemeteries ourselves. It would cost several $1,000s to do it. They started this flower program themselves. So I'm going to tell you exactly what happened to me, but I want you to know I'm not the king of the hill here. We're representing a lot of people. So my experience is just one of many, but it's a good example. I found out about that flower program in 1974 when I stand at my dad's grave, and the superintendent of that cemetery heard there was family there, and he came out and introduced himself to me and told me about it. And I had no idea it even existed. They've never truly advertised it to this country. So from 1974 for the next 41 years, I decorated that grave 3 times a year. I'm going to tell everybody in this room, there was never a problem. There was never a hiccup. There was never anything but just good service. What did that mean to the people that, like myself? When you lose your dad to a sudden, violent death, protecting the freedoms of this country, there's a hole created in your heart that doesn't close. It's that simple. So that flower program meant something. I mean, it meant something. And it meant something to everybody in this country, whether they know it or not. So I decorated that grave over 123 times, if you do the math on that itself as well. Right before Memorial Day of 2015, we get a note from the ABMC. We're not going to do that anymore. Pardon me? We're not going to do it anymore. Well, I was here this morning. I heard what they said. Thank you, the ABMC. They finally have listened to it, but it's taken an act of Congress to get them to listen to it, and it has, for that matter. Let me tell you a few other things that you should know. And I'll be honest with you, I'm the guy that started this fight, but that's all right, for that matter. And what they were saying is what was going on was so easy for if we wanted to do it the way they wanted to do it. In other words, let me back up here. When they ran that program, I'm going to go back to the point we had no problems at all. It worked smooth as glass. The lady that's sitting behind me, who I said brought with me, when she tried to go about it through the method the ABMC had, for that matter, her dad is in Luxembourg. He was a B-17 pilot that ordered in. He's buried in Luxembourg at their cemetery. She personally called every florist in that country. None of them spoke English. They didn't, regardless of what you hear from the ABMC. That's why we didn't have a problem with that kind of thing. The problems we had was language barriers, money. We don't understand their money. The prices of these flowers, once they stopped it, tripled. It was just terrible. And people quit buying them, and because of that, quit honoring them. But let me tell you another thing as far as honoring honoring soldiers, the Americans. Now, I'm one of 183,000 American kids, now adult kids, if you will, that lost their dads in that war. He's buried in Holland, in Margaret in Holland. 8,301 Americans are buried in that Holland. Every grave in that cemetery has been adopted by a Dutch family. They're on their third generation of doing that. There is a waiting list of people that does that. What did our country do? They dropped it. It takes an act of Congress. Doesn't quite fit. That's not the heritage this country wants to leave, for that matter. I go back to the point that we live in the freest country in the history of this world, and they want to drop this flower program. I was real interested today when they said, we're going to do it and we'll be proud to do it. That's fine. And I loved what Representative Zinke said. You ought to listen to the people you serve. And that's basically what he meant, and I just really enjoyed hearing that kind of thing. We're not trying to be their enemy. We set out trying to be their friend, but they wouldn't give us the time of day. They wouldn't listen to us. That's why we had to go this route, for that matter. We today are the voices of our fathers that are laying in these cemeteries and in the dirt of these countries, and they're not here. And the reason, if you want to know, that they didn't bring them home, our government, was a cost factor, trying to ship all those bodies home. The government, had to get our family's permission to bury our family member overseas. Our family gave the government a favor doing that. The government needs to return this favor a little bit, for that matter. So, when the ABMC walked from this, it was like somebody pulling something out of your heart. And I try not to be a too emotional guy. I think I'm pretty tough, but maybe not as tough as I think I am. But it was just an absolutely horrible thing to do to the Gold Star families. And there's a lot of people who are not real happy about that. It's that simple. So that's what I'd say to you today. Thank you for listening to me. Please, please see this bill. One other thing.
You're going to have to wrap it up, Mr. Holliday. I've given you 3 minutes extra.
Well, I hope I won't need that.
Oh, I've already given them to you. You're welcome.
Thank you. If this bill passes, don't let them farm this out to a third party. They tried that with us before. It's the first thing they wanted to do. And I'll be honest with you, I've been to DC 6 times on this thing, trying to get this done, not by myself, but with others. First thing they told me was, go get $2 million for our budget. Me, I'm gonna raise them money. I went home to Iowa, and I know Senator Ernst pretty well, and I called Senator Ernst. And she said, Bob, let me tell you something. She must have been on the Senate Veterans Affairs Committee or something. She said, go back to them and ask them what they're gonna use the $2 million for. And I did, called them on the phone. You know what the answer was? We haven't quite worked that out yet. They were gonna farm it out. Give them $2 million, they're gonna hire a third party just to run it, and they could step out of it. It would have been one more thing off their plate, in my opinion. But they're forgetting the fact, I'm gonna repeat this, everybody within the four corners of this country lives in freedom, and that's been paid for. Stick with it. Don't walk away from these goals for our families. Thank you for letting me speak to you.
Yes, sir, Mr. Holliday. Mr. Keogh, you're now recognized for 5
Thank you.
minutes.
And thank you, Mr. Holliday, thank you to all the Gold Star families. Chairman Luttrell, Ranking Member Pappas, and members of the subcommittee, thank you for inviting AFG to participate in today's hearing. On behalf of AFG and the NVAC, representing 300,000 VA employees, it is a privilege to offer insights to the subcommittee on legislation being considered, particularly bills affecting the VA workforce. The primary reason I come before the subcommittee today is to express AFG's strong support for the draft legislation known as the Board of Veterans' Appeals Attorney Retention and Backlog Reduction Act. AFG applauds Representative McGarvey for sponsoring this legislation that will help the board retain its attorney workforce by making the full performance level for non-supervisory decision-writing board attorneys grade 15 of the general schedule. As Local 17 President Doug Massey testified to the subcommittee in November, the board had a GS-14 career path for attorneys for many decades. However, in November 2021, board leadership downgraded the career path to GS-13, which undermines this committee's goal of recruiting and retaining legal talent to serve America's veterans. Reducing the level of compensation for attorneys dissuades qualified applicants from choosing to work at the board or from choosing to stay long-term. Instead of attempting to remain competitive, board management has widened the pay gap between board attorneys and the private sector. AFG believes that this committee shares our commitment to ensuring that disability claims for veterans and their families receive the highest level of attention. And that board management's policy change is contrary to that goal. Following Mr. Massey's testimony, we're glad to see that members of this subcommittee do not agree with this penny-wise and pound-foolish treatment of board attorneys, especially considering the critical role we play for veterans, the relatively small size of the board, and the nuanced expertise required to properly adjudicate veterans' claims. If enacted, Representative McGarvey's bill will authorize the board to promote non-supervisory decision-writing attorneys to the GS-15 level. With this authority, the board can fulfill the goal of retaining senior attorneys who have institutional knowledge and expertise in veterans law. This will encourage these attorneys to stay at the board and not look for jobs elsewhere. Furthermore, by making the full performance level for board attorneys GS-15, will also undo the board's GS-13 promotion cap for new attorneys. This increased retention will also benefit the board financially by reducing expenditures on recruitment and training of new attorneys by reducing turnover. Most importantly, this will help keep the most experienced and productive board attorneys at the board long-term to continue serving America's veterans. There is precedent for Congress taking legislative action on compensation issues at the board. In 1994, Congress passed legislation to place veterans law judges on the ALJ pay scale. Historically, veterans law judges were GS-15s and their staff writing attorneys were GS-14s. By enhancing the compensation levels of the adjudicators signing board decisions, retention levels for veterans law judges significantly increased and the retention issue was resolved. Today, this legislation would also resolve the retention issues caused by highly qualified decision-writing attorneys leaving the board for the VA Office of General Counsel and to other agencies for greater compensation and a better work environment. The latest Best Places to Work in the federal government rankings, issued by the Partnership for Public Service and Boston Consulting Group, released in May 2024, has the board ranked at 444 out of 459 federal agency subcomponents. Again, 444 out of 459, by far the worst ranking in all of VA. By contrast, the VA Office of General Counsel, where these non-supervisory GS-15 attorney jobs exist, is ranked 81st. This dismal ranking from board attorneys is largely due to unreasonable workloads and pay that is not commensurate with the increasing complexity of veterans law. This legislation, by establishing a career path to GS-15, will address the compensation issues which have made recruitment and retention such a challenge at the board. Consequently, it will help reduce the current 206,000 case backlog by incentivizing highly proficient and productive attorneys to stay at the board rather than leave for better opportunities elsewhere. Thank you for the opportunity to testify today and present AFG's views on this legislation. I look forward to answering your questions.
Thank you, Mr. Keogh. Ms. Wheeler, with the veteran service organizations that seem to dance around helping veterans in parallel to TAPS, and I get the argument that some are out there that, like you said, they're sharks. They're taking advantage of the veterans. Do you agree that there are organizations out there that work by, with, and through TAPS or assist TAPS in any way to help veterans with their claims? Because TAPS is TAPS, right? And you and I could probably get into a debate on how successful TAPS is to date. Do you agree that there needs to be other organizations out there assisting veterans besides TAPS or not?
Absolutely, sir.
Okay, good.
So we actually are there to assist survivors, but we are not an accredited VSO. So we do help survivors with the process, but we work through accredited VSOs that help with survivor claims. So yes, we think they're very important, and I stipulate that it needs to be accredited VSOs. And we believe that they do a tremendous service for our veterans and survivors.
That would put TAPS and other organizations in their comfort zone if we made an organization be accredited.
Now, there are still good and bad actors in this space, and there are, I should say, there are accredited free services. That's really what we're looking at. There are a lot of these consultants, they call themselves, that have come into this space that want to charge veterans and survivors for their service. And there are accredited VSOs that are there that do it for free already, that do a tremendous service.
And TAPS shares that information out of a portal or a database or an enclave with those in need?
Yes, if we have a survivor call us, then we can help walk them through the process. But if there is a veteran that calls us, and oftentimes we do get veteran calls every day, honestly, and we will refer that veteran to one of the accredited VSO partners.
So I can share with all the veterans I have in my district and nationally that if I get those questions, I could say, contact TAPS, and they will guide you through the effort.
We can do that. It's better if they talk to the Veteran Service Organization directly that can help them with their claim. But we are there for families, and because we're not an officially accredited organization at this point to do a claim, we then refer those veterans to other agencies.
Okay, thank you.
Thank you, sir.
Ms. Witter, I kind of got lost in veterans benefits and the purchase of an urn. Clarify that for me, will you please?
Thanks, Mr. Chairman. So I spoke to a lot of veterans about this, including the current president of NFDA, who's a veteran and a funeral director. And so we look at this legislation as empowering families to make informed decisions regarding their loved one's final resting place. So, as you know, a veteran is entitled to funeral and burial benefits, but so is the spouse. So we came up with a scenario where a veteran could die and the spouse might decide that he or she wants to keep the veteran's urn at home with them until they pass. At that point, the veteran is no longer entitled to ground burial because the burial benefit went for the urn. So the spouse is entitled to be buried in a veteran national cemetery, but the veteran is not. So obviously this is not a great situation. I think this legislation goes towards helping that in an ideal world. we wouldn't love to see veterans' families having to pay for an earn, but at the moment, there is no option. So once you accept that benefit, then you're done. The veteran actually loses the right to be buried in a cemetery, which every veteran I spoke to said that that's one of the highest honors. They consider that they've earned that benefit and they don't want to lose it because in a moment of grief, their spouse says, no, I don't want to leave my husband. I want my husband's urn with me until I die, assuming that then they will both be entitled to burial.
Interesting, okay. Mr. Holliday, this is a yes or no question.
I don't like those.
You got 20 seconds.
All right.
And I'm going to burn 10 of it down just asking you this question.
All right.
Given the testimony of Mr. DeJean today in the first panel, are you happy with what he said? Yes or no?
Yes.
Thank you. All right. Mr. Pappas, you're now recognized.
I was happy to hear it too. But thank you, Mr. Chairman. Thanks to the panel. We really appreciate your inputs on these pieces of legislation, the vast majority of which are incredibly non-controversial, bipartisan, and we really hope we can get them through the Congress and signed into law this session. Mr. Keogh, if I could start with you. I appreciate what you and all the frontline VA employees do day in and day out for our nation's veterans. I wanted to ask about H.R. 8874 from Mr. Valadeo, who we heard from earlier today. I agree that VA needs to be looking at how it can deploy automation to help assist our VA employees, help our veterans. But what I hear from the veteran population is that they don't want to just know that a bot is going to be dealing with their claim or processing their information. They want to know that there's a well-trained person on the other end of that transaction. So I'm just wondering how AFGE feels about VA's current automation efforts and where you think automation tools can help employees in their day-to-day work supporting veterans, where they might prove a hindrance.
Thank you for the question, Congressman. AFG supports using new technological tools to streamline the claims process because America's veterans wait entirely too long. AFG opposes any steps to replace employees, frontline employees, with technological tools. Additionally, we support comprehensive training for all frontline employees with dealing with new technology. That's something that VA management has been difficult in the past, that they don't always provide the comprehensive training that we would like. In terms of it, technology can be of assistance in terms of reviewing claims files, but again, we would want to make sure that no frontline employees are replaced due to technological changes and that training is done comprehensively on any new changes. Thank you.
Appreciate that feedback. And Ms. Wheeler, maybe I can turn to you next. Thanks very much for your testimony, and appreciate you highlighting a couple of the bills that I've introduced on the slate today, including the Burial Improvement Act. You also mentioned the Survivors Benefits Update Act and some concern that TAPS has around one of the provisions in the bill, and I really appreciate those comments. We're going to put a lot of weight in terms of what you had to say today about that piece of legislation and how we can work to shape it moving forward. I'm curious, though, in lieu of that specific provision that you had an issue with, are there other places in the application process for survivors' benefits that we can push VA to find some efficiencies? The goal here is to get survivors their benefits more quickly with less difficulty, so any feedback you have on where VA can do better there, I think would be helpful.
Yes, thank you for that question, sir. And part of what we see is in this discussion of using those tools that are out there, the advancements in technology, and being able to focus those on our veteran and survivor claims process. It has worked for disability. It has actually improved that process, and we could see that that would be very helpful in the survivor space as well. And for veterans' benefits, but especially when we're looking at survivor benefit claims. We're still seeing a lag and a backlog in trying to get through those. We have been concerned in how the letters even come out to our survivors and knowing what they should even choose in terms of benefits. So one of the pieces of legislation we've been looking at and we talked about earlier was the fact that our survivors are covered by being able to do one claim form for all. And we think that's important to continue to keep that so that survivors can actually, they don't always know what to apply for. And so we think it's important that they do one claim form that is used for all. And that is one of the things we could see that VA could continue to do to help. So thank you, sir.
Well, thanks very much for your work. You assist these individuals during an incredibly difficult time, often in their lives, and making sure that they get the help they need as quickly as possible has got to be a top priority. So thanks for your work, and I yield back, Mr. Chairman.
Thank you, sir. Mr. Crane, you're recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Carey, is it true that you're a veteran yourself?
Yes, sir, retired Navy.
What'd you do in the Navy, sir?
Started off as a ship driver and then became an A6 bombardier navigator. And then in the reserves, I was everything that the active duty didn't want to do.
I got to ask, what does shoe bob mean?
Started off as a black shoe, became a brown shoe.
All right.
And the brown shoes didn't like that, so they gave me a bad call sign. No one gets a good call sign.
There you go. All right. Mr. Carey, can you explain why VA's practice of sending the names of veterans with fiduciaries to NICS, National Instant Criminal Background Check, is a violation of those veterans' constitutional due process rights?
Because the underlying fiduciary determination program is in and of itself a violation of the due process. There's no independent authority overlooking this. There's no judicial oversight. There's no judicial action. The veteran is required to prove their competence, not the VA is required to prove their incompetence. The entire fiduciary program is a violation of the veteran's due process. And then to add insult to injury, then the VA reports them to the NICS database, and now, based upon a faulty determination of mental defective, they are then they're then informed, oh, by the way, you can no longer purchase or possess a firearm. And the effect of the program leading to their loss of their gun rights is also a taking and a violation of due process, and a violation, I think, of the 14th due process and no taking of life, liberty, or property without judicial due process.
Yeah, and you said that any clinician at the VA could assign a veteran that they are treating a fiduciary. Is that correct?
Can refer them to the fiduciary program, and a lot of them come from that. It's the doc asks the veteran, how are your finances? Oh, my spouse takes care of all that, and they take that as, oh, you know what? You are you should probably be referred to the fiduciary program. It's that level of it's that lack of level of analysis by the rating official or the clinician that leads to that.
Mr. Carey, and this is something that I asked Mr. Friel about, have you seen any studies, because I know you're studying this in some of the work that you do, that show that veterans are more at risk of firearm suicide if they're simply unable to balance their checkbook or need help with their finances?
No, and in fact, what the whole mental defective issue is saying is that we are predicting that this person has a mental health issue, and they're a mental defective because of that. And so there's been significant studies that show no correlation between mental health illness and gun risk. Education Fund to Stop Gun Violence, now the Johns Hopkins Center for Gun Violence. Mental illness is not the cause of gun violence. Dr. Jeffrey Swanson down at Duke, can we reliably predict violence? No is the short answer. Psychiatrists using clinical judgment are not much better than chance at predicting which individuals will do something violent and which will not. There is correlation between poverty and income inequality and violence, but that is overwhelmingly, but there's also a lot of studies that say, yeah, and you know what? That sort of underplays how much violence there is in white communities and overestimates how much violence there is in communities of color. And so therefore, those poverty and economic inequality determinants are in fact not statistically valid.
The last thing I want to ask you, Mr. Carey, is about Mr. Friel's comments that if this Congress was to pass a law to fix this, that the VA would not comply with that law. What did you have to think? What do you have to say about that?
It underscores how the VA really doesn't care. I mean, the whole purpose, how this all came about in the first place, is that when the Brady Gun Violence Prevention Act made the NICS database back in 1994, in 1998, the White House is saying, oh, there's not enough people that are being classified as mental defectives in the database. It's looking like a failure. And so some enterprising bureaucrats within the Department of Justice and the Department of Veterans Affairs got the Department of Veterans Affairs to submit their own comment on the regulation saying, fiduciaries are also mental defectives. We'll start sending them in. And it was to plus up the numbers. So, I think this is a solution in search of a problem. And the VA has consistently shown itself to go that route. And they cannot be trusted. And even if the secretary were to abide by what Mr. Friel recommends and not not abide by the law, it would still give us a lot more power having this law passed to be able to take it to court.
Thank you, Mr. Carey. Mr. Chairman, I yield back.
Thank you, Mr. Crane. Mr. McGarvey, sir. You're recognized for 5 minutes.
Thank you, Mr. Chairman. Appreciate everybody being here today. I'm going to ask some questions about my bill, which is the Board of Veterans Appeals Attorney Retention and Backlog Reduction Act. And what this bill does, very simply, it allows the BVA attorneys to reach a GS-15 and not be capped at GS-14. In and of itself, this bill does not mandate any new hiring or promotion of attorneys. It simply gives the BVA the flexibility and tools to increase the pay if it so chooses. So, one important point, it also allows it within the current appropriations it already has. So, Mr. Keogh, as an attorney at the BVA, you know more than anybody else about the changes needed there. In the May 2024 Partnership for Public Service Best Places to Work and Federal Government Rankings, what is the BVA ranked?
The BVA is ranked 444 out of 459 federal agency subcomponents in the latest Best Places to Work issued by the Partnership for Public Service.
So out of the best places to work, with 1 being the best and 459 being the worst, BVA is currently 444th, which is 15 spots from rock bottom. It's also, and I think this is important to point out, it's 188 spots below the next VA office.
That's correct.
And yet BVA management is opposed to this bill because according to the BVA management, their current recruitment and retention incentives have proven to be, quote, very effective. Mr. Keogh, do you think that's accurate?
I would be very skeptical of any assurances offered by a management team that's managed to run an organization into the ground. When you're at 444 out of 459, it doesn't get much worse than that. This current team, you never know, they may be able to hit 459 next year. It's hard to predict. Absolutely, I think that the employees are unhappy. I've known numerous highly qualified attorneys, productive attorneys who've left. They're now GS-15s at different agencies. They're moving up the ranks at other agencies, and as a result, they're not there to issue those decisions on those complex cases. And as a result, America's veterans have to wait longer because of the current board management's inability to retain the current talent that they have, and they are continuously trying to hire more and more people.
So let's drill into that just to put a very fine point on it quickly. Terrible ranking in best places to work. You just said you have seen attorneys leave because of pay, correct?
Correct.
But they're going to other government agencies because in another government agency, even within the VA, they have an ability to be a GS-15 rank, but they do not at the BVA.
That's correct.
All right, and that's all we're trying to do is give that flexibility. You also, and I think, brought up a very important point, which is we're doing this to take care of the veterans. Right? We're doing this to make sure that veterans' claims and the backlog is worked through. We only have 1 minute and 40 seconds left, but can you elaborate on how long it takes board attorneys to become proficient in their jobs and what some of the value of retaining the best and most experienced attorneys is at the board to the veterans?
Yes, thank you for the question. That's a great point. It's an incredibly complex area of law, veterans law. It's constantly evolving. There are precedential decisions coming out almost daily from the Court of Appeals for Veterans Claims, from the Federal Circuit. Additionally, regulations are changing, laws are changing, the PACT Act that Congress enacted a couple of years ago also significantly changed the claims processing for some of these claims. The Appeals Modernization Act, passed in 2017, also did so. So attorneys must be proficient on both the legacy system of appeals and the Appeals Modernization Act appeals, which those are different rules you need to apply. I know that a colleague of mine testified that the veterans law may be more complicated than the tax code, and I think that that's fair to say. It's a very difficult, esoteric area of law. It really takes attorneys hundreds and hundreds of cases to develop that kind of knowledge, and years of work. And then when those attorneys leave, I've known many talented ones for the Office of General Counsel. As a result, that knowledge is lost, and they won't be adjudicating those claims for American
I agree with you, and
veterans.
I want to finish up here because we're running out of time. Like a good attorney, you took a lot of it. And there's an old saying, you want a young doctor and an old lawyer, and I think you just put that in the amount of words a lawyer would. But I'm going to say this really quickly. The budgetary concerns are the reason the BVA cites to oppose this, but they'd returned $15 million last year. That is 1,500 attorneys in the 10,000 difference between a GS-15 and a GS-14. We can afford it. We can afford it. The real question is, can we afford not to? And I think for our veterans and for the care they deserve, that answer is clear. Thank you, Mr. Chairman. I yield back.
Thank you, Mr. McGarvey. Thank you to all the witnesses for testifying before us on these important proposals. These bills discussed today will ensure that we properly honor our fallen service members and veterans at home and abroad. They would also protect the constitutional rights of our veterans, improve the VA disability claims process, and improve access to VA benefits for veterans and their families. I look forward to working through these issues with the VA and ABMC and my colleagues on the subcommittee. Ranking Member Pappas, you're recognized for closing remarks, sir.
Well, thank you. Thank you to all the participants in the hearing today. I think you provided us with a lot of really terrific information to go about our work moving forward. Before I close, I just want to mention a tragedy that's hit close to home in my district in New Hampshire. It's the untimely loss of Brigadier General John Pogorek. He was the commander of the New Hampshire Air National Guard. He was sadly killed in a hit-and-run accident just a few days ago. And I'm thinking of him today and his family. He was a 1989 graduate of the U.S. Air Force Academy. He was named commander of the New Hampshire Air National Guard in 2022 after a distinguished career in both the Air Force and the Air National Guard. So my thoughts are with his family and his loved ones at this difficult time, and General Pogorek's absence will be felt immensely, both in his community and the New Hampshire National Guard community as a whole. I yield back.
Thank you, Mr. Pappas. I want to close with and what we've heard today in the multiple panels, and there's always a friction point. There'll always be a bubble up, but I want the VA, and I don't know if the secretary is going to hear this now, but the VA, the machine itself it's doing the absolute best that it can with the problem set that it's presented with. And the veterans are hard to wrangle, right? And there's so many different intricacies that go into what they see, how they act, and how they react every single day, period. So I want to applaud the VA for the work and the continued work that they do, but always I'm sure the VA is going to understand this. It is our job on this committee to make sure that we hold and held them accountable for any and all actions, which we have done today. Legislation moves forward in order to course correct ships that are out of sorts, but every single individual that works at the VA carries an extremely heavy rucksack. And if you don't think that they don't, I highly recommend you work for the VA for a little while. I've never done that, but I engage with every single person that is on this committee and after the fact, and I can assure you, they lose sleep every night. And I will happily argue that with anybody outside these quarters right now in the hallway if you want to. So with that, I ask unanimous consent that the statements for the records we have received will be entered into the record. Hearing no objections, so ordered. I ask unanimous consent that the members have 5 legislative days to revise and extend their remarks and include extraneous materials. Hearing no objections, so ordered.